once again for your Let's Talk Legal compliments of Newman van Rooyen attorneys. And once again, we do have Tumi Mokobe with myself here in studio. Tumi, thank you so much for joining us.
Thank you very much for having me here.
So today we are chatting a bit more about the procedure of being a complainant in criminal matters. Now, what is the general procedure of opening a criminal case against someone?
In that regard, the first step in opening a criminal matter against a person would be to attend to your nearest police station and report whatever case you're opening at the receiving police official. And then the next step will be that the statement will be taken by the police official and you shall be allocated with a case number. Thereafter, the docket shall be allocated to an investigating officer, which are the police officials in private clothes. That's how you easily identify them, that they're actually investigating officer. And he shall notify the accused, which is now the person that you opened the criminal matter against, or go to the accused straight without prior notice in case of serious crimes and so forth, in order to detain the person if necessary.
Now, do I need an attorney or any legal representation during such a process?
No, not at all. You as the complainant is basically represented by the state, which is the prosecutor in this regard. Therefore, you need not see or nor consult an attorney unless you are intending to institute a civil action which is related to the criminal matter which you are opening. Then it might be essential to notify your legal practitioner in that regard. But he will not be representing you during the criminal proceedings at any stage. The prosecutor shall have your back in that regard.
Now, sometimes a lot of people would attend court right after they opened a case as a result of SMSs that they received from the investigating officer in relation to the matter, but only to be told to leave because they are just not needed. Can you clarify this position?
As I've indicated earlier, that usually when you open a case, you would get a case number. And then the investigating officer, every time the matter goes to court, will update you by way of SMS or maybe telephonically contact you and so forth. And should it be that the matter goes to trial, you shall be subpoenaed by the investigating officer handling your matter. So basically, every time you get an SMS, you should just take it as an update. You shouldn't go to court, or when you are notified that the next court date is the 13th of August, it doesn't mean that you should go to court. The investigating officer in that regard will personally come to you in order to subpoena you, in that you will explain that you are currently needed at court on this day because you need to testify in relation to your own matter.
All right, so how would you then know when you are actually needed at court?
As I just indicated now, that the investigating officer in charge of your matter will come personally to your house or to your workplace or wherever in order to notify you by way of subpoena. It's a legal document which you actually need to sign in order to prove that the document has been given to yourself and you have been notified pertaining to the next court date.
Now, may the police tell or advise me on what I should do when I want to open a criminal matter?
I would say not really. However, it depends on what they advise you, because sometimes people tend to go to court with to the police station actually, with civil matters, and the police in that regard cannot assist you because they only deal with criminal matters. But they will subsequently refer you to an attorney if it's something based on a civil matter. However, if you tell the police that somebody has hit you and so forth, that's just a practical example, they should not advise you to open a protection order against that person, but they should just do their job and open a case. They can, however, afterwards advise you to say that you also have this option of opening a protection order at court. However, that is subsequent to them opening a criminal case in order to assist you.
So if a person opens a criminal case, is it also possible to institute civil action against that person, or do I have to choose between the two?
You know, you have a right to actually institute both, whether you decide to do it at the same time or you decide first to lay criminal charges and then afterwards do your your civil matter. The choice is all yours. If you can prove that you incurred damages, you may institute civil action while you also open a criminal matter against the same person. The rules of law actually differ in both instances, so it's always open to whichever journey you decide to take, you may do so. So it's not a matter of you're confined within the space of only opening a criminal matter or only a civil matter.
All right, Tumi, once again, thank you so much for joining me in studio.
It's a pleasure, man. Thank you for having me here.
So that was, of course, this week's Let's Talk Legal, brought to you by Newman van Rooyen Attorneys. Remember to visit their website at www.nvrlaw.co.za.
Bye.